Thanks for staying with us. MGM Mirage says it's earmarking $20 million for a contingency plan should its city center project seek bankruptcy protection. In a regulatory filing this week, the company says it's putting aside the money necessary to, quote, ensure public health, safety, and welfare or regulatory compliance in connection with city center holdings. The Las Vegas Sun reports a source close to the MGM Mirage says the fund is not an indication that bankruptcy is imminent. The fund would allow City Center to wind down work on the project while it restructures its debt. The project's future has been in doubt since MGM's partner, Dubai World, filed a lawsuit claiming MGM cannot fulfill its financial obligations. But that same week, Dubai World failed to make its half of a $200 million payment to the project's lenders. MGM Mirage ponied up the entire amount. And disgruntled buyers of those MGM Turnberry signature condos won a round in court this week. The buyers claim they were promised returns on their investments that have not panned out, and they say the MGM Mirage should have sold the condo units as securities. A federal judge this week paved the way for a jury trial in the case. The MGM Mirage wanted the dispute resolved in arbitration. In a statement to the business, the company said, the company said the plaintiff condominium purchasers each signed purchase and sales agreements with arbitration provisions which afford them a forum, the American Arbitration Association, in which to pursue their claims. And the company went on to say it plans to appeal that ruling. And joining me now to talk about it, the attorney representing some of those owners who are suing, Bob Gerard. Thanks for joining us.
Oh, thanks for having us back, Dana.
First of all, how many plaintiffs do you have now?
We currently have about 140 units, total of over 200 plaintiffs.
Wow. So tell me, why is this a key ruling? Obviously, you wanted to go before a jury because you feel a jury would be more sympathetic to your plaintiff's plight.
Well, it's true for a number of reasons. First of all, we always feel comfortable in the court system because then we get a jury of our peers. But more importantly, the arbitration provision in this case had limitations. They limited discovery to 2 depositions. We felt it was one-sided in terms of attorney fees. In situations where MGM was not entitled to fees, they may prevail and get fees. There were no punitive damages. There were confidentiality provisions. Basically, what we want is a fair forum. In the court, our courthouse is a fair forum.
You know, when you filed this lawsuit a little more than a year ago, the gaming industry was still doing relatively well. Yes. MGM Mirage was doing well. Things have changed since then. Do you think that the environment today, or when your case goes to trial, will affect those claims? Do you think a jury would have more sympathy, for instance, when MGM was living high on the hog?
Well, there's no doubt. MGM is the largest employer in the state. And many people look to see whether or not their financial well-being will impact them. But I think what we're dealing with here is a partnership, not only MGM, but with Turnberry. And I believe when the jurors see the facts of this case, they're going to recognize that this is another example of a failure to regulate. And the importance for the consumer to be out there with just fair protection by the government, I think, will be paramount. So I believe the jurors will understand it's very tough economic times, but we're confident they'll do the right thing.
Okay. One of the key allegations was that MGM should have sold this as a securities investment rather than a real estate investment. And I want to read from the contract. It says, except for the warranties contained in the deed of conveyance and any written warranties delivered at closing, no warranties, express or implied representations, understandings, guarantees, or promises, including in the warranties set forth in the Act, have been made to or relied upon by buyer in making the determination to execute and close pursuant to this agreement and to the maximum extent permitted by law. All warranties, including implied warranties of fitness for a particular purpose, mechanability, and habitability, and all warranties imposed by statute, except to the extent that they cannot be disclaimed, are disclaimed. You know, there's a lot of fuss now about people who got into mortgages saying they didn't know what they were getting into. That pretty clearly says, to me at least, if I were a buyer and I read that I can't rely on any of the representations made by the salespeople. Why do you think a judge or a jury should set that aside?
You know, the most important thing that we can demonstrate, and we have handwritten notes and other physical evidence, but what we can demonstrate, there was a commonality with the sales approach. And one of the things about being MGM is the credibility with MGM. So when you go to a sales presentation and you're told this is a great investment, if you're told you can own a piece of the Strip, and more importantly, MGM will manage your room for you, and the rates based upon occupancy are greater than 90%, and the room rates will be greater than $300 a night, you believe them. And then when you're presented with a contract at the conclusion of the sales presentation, you have no reason to believe that what they just told you is not true or shouldn't have been said.
You know, very quickly, there was so much made of Terry Lanny's credentials and whether he had gotten his master's degree at USC. Is that something that would even figure into your lawsuit?
You know, it does. I think the credibility, the brand name of MGM, which people had so much confidence in, is going to be an issue in the case.
Okay. Mr. Gerard, we are out of time, but we will stay on top of this and have you back.
Thank you, Dana.
Jeff?
All right, Dana, thanks much. Falling room rates at strip hotels have one older casino struggling to pay its bills. That's the word from one analyst who says the Riviera's failure to make a $4 million loan payment this week can be attributed to increased competition at the low-end price point.
As the Excaliburs and the Circuses lower their room rates to attract customers, you know, it puts even more pressure on a casino like Riviera. So it's not overly shocking to hear them cite that as one of the bigger reasons why you know, they didn't make their interest payment.
The Riviera is in talks with Wachovia Bank about restructuring its debts outside of bankruptcy court. Station Casinos has missed a third loan payment. The company skipped a $13.5 million payment due Wednesday. Since January, Station Casinos has failed to make 3 payments, totaling about $44 million. The company hopes to file a prepackaged bankruptcy reorganization, but has yet to secure approval from its bondholders. The locals gaming giant, meanwhile, widened its loss, $3.2 billion in the fourth quarter. That's compared with a loss of $437.4 million the year before. For the year, Station Casinos posted a loss of about $3.3 billion. That compares with a loss of $395.5 million the year before. Another resort says it is missing an interest payment. This week, Hooters Hotel Casino said it will not be able to make a payment on its senior secured notes. Missing the payment may lead the casino to file for Chapter 11 bankruptcy protection. Hooters operator, which is 155 East Tropicana LLC, had debt of almost $145 million as of March 3rd. After the non-payment, which occurred Wednesday, note holders could claim default following a 30-day grace period. 155 East Tropicana says it has about $8 million in cash on hand for operations. Hooters employs 874 people. And the parent company of the Stratosphere saw profits disappear in 2008. American Casino and Entertainment reports a loss of almost $37 million last year. That compares with net income of almost $39 million the year before. The economy forced the company to write down the value of its assets, which contributed to that loss. Now moving south down the strip, the parent company of Planet Hollywood narrowed its loss in 2008. Planet Hollywood Resorts lost $45 million last year. That's an improvement from a $75 million loss in 2007. The company also reported a 7.5% increase in revenue in 2008. Dana.
Thanks, Jeff. Nevada's publicly traded gaming companies saw stock prices fall in March. Applied Analysis reports MGM Mirage experienced the largest drop, with shares falling 47%. Shares of Las Vegas Sands Corporation fell 29%, while Wynn Resort stocks dropped 23%. Ameristar Casinos posted the largest increase. Penn National Gaming and WMS Industries also saw a rise in their stock prices. And shares of Las Vegas Sands rose Friday, thanks to Sheldon Adelson opening up his checkbook. Sands says Adelson recently bought 4.7 million shares of company stock. The transaction helped push Sands' share price up 12 cents to close at $4.52 in after-hours trading on Friday. Sands is off its 52-week low of $1.38 a share. Two well-known attorneys are joining the Nevada Gaming Commission. Governor Jim Gibbons appointed Joe Brown and John Moran Jr. to the regulatory board this week. Brown is president of Jones Vargas Law Firm and has served on the Nevada Athletic Commission. Moran is a partner in the Moran Law Firm. He's a former chairman of the Colorado River Commission. They replace outgoing commissioners Sue Wagner and Arthur Marshall, and the appointments mean all 5 gaming commissioners come from Las Vegas. And when In Business comes back, gay rights advocates win big at the state legislature. We'll tell you about it. Plus, have you prepared for the upcoming hike in the minimum wage? We'll tell you what to expect when In Business returns.
You're watching In Business Las Vegas. with Jeff Gillen and Dana Gentry, a program presented in partnership with the Las Vegas Sun, Cox Communications, and KLAS TV.